under New Jersey law. It's unnecessary. It only has an insidious underlying purpose to target the Muslim community.
Last question. You mentioned this earlier, sir. Said that Sharia law is not necessarily codified. In other words, it can be applied differently in different Muslim nations, and it is applied differently. So it's not like they can point to Sharia law and says, here it is, here's the regulation under Sharia law, where it might be one way in Egypt, another way in Saudi Arabia, another way in Iran. So that also calls into question.
But
why would you want to apply something called Sharia law?
Okay. First of all, the way it would work, let's use examples to illustrate. If I say no Sharia law should be considered by a judge, and I'm testifying about Egyptian law that codifies Sharia, therefore, in my testimony, I will be discussing and explaining the Sharia rules that the Egyptian law is based on. Because in most of these jurisdictions, in Egypt, in Syria, in Morocco, in Libya, there's a gap filler. Almost every civil code in the Arab world provides, if there's no express rule in this civil code, if there's no express rule in the family code, the judge relies on Islamic law according to the Hanafi school, the Shafi'i school, the Maliki school. And Sharia is that primary source of a lot of legislation in the region. So sometimes, like for example, I did a case on Iraqi law. And I represented the American company against a huge tort action. Tort took place in Iraq. The issue was, does Iraq provide for punitive damages in a tort case? Pain and suffering and punitive damages. Well, according to my interpretation of Iraqi law does not provide for punitive damages. And because the Iraqi civil code specifically says, my code civil is based on Sharia, I went to Sharia sources to support the position that the interpretation of Iraqi civil code is consistent with Sharia law, which does not provide for punitive damages. So would that part of my testimony not be admitted in court? So the issue is these general prohibitions miss the nuances and legal subtleties. Our Constitution is strong. It's the law of the land. We have the balancing tests that are necessary to allow the judges who are closer to the case, who see the litigants, who see the entire evidence, they can make those decisions. All they need is guiding principles from the Supreme Court on the balancing. We have the Lemon test, we have Larson, we have Wolf that talks about the neutral principles. We don't need a bright line rule. The bright line rule is only targeting Muslims.
In the context of parole evidence, do parties generally explicitly state which school of Sharia interpretation they want to prescribe to? And also, do you think that it would be entirely impractical to just essentially enumerate exactly how you want, say, your bill to be carried out or whatever, rather than say I want it to be based on Sharia law?
Is it impossible to leave that up to the judge? As opposed to, see, you know what happens is when you create rules, then you want to start having exceptions to exceptions to exceptions. So the general rules are going to create more litigation, more problems. All we need is guiding principles. The Constitution is the guiding principle in all the cases I handle. If it is inconsistent, it's not going to be recognized. I mean, even state courts that draft legislation that's inconsistent with the Constitution are set aside. So the same principle applies to a foreign law or to parole evidence.
Professor Watt, so in the case of Lawrence versus Texas, the United States Supreme Court invalidated state statutes based upon as persuasive evidence they used a case in Britain. Could it be the case that a federal or state court in Oklahoma could similarly use a foreign ruling that's not binding on America to invalidate a local rule?
No, I don't think they could, but let me explain to you, because what's good for the goose is good for the gander. I worked on this fascinating case that involves a high-ranking United States general. And it involved a case international, but one of the issues was whether there are general principles of law around the world that there is a presumption in favor of the surviving parent to take custody. So let's say I drop dead and kick the bucket. Does my wife have the surviving presumption to take custody of my kids? Or is it the maternal parents? So in this particular case, we used general principles from around the world to convince a U.S. court that there is an international general principle, that there is a presumption in favor of the surviving parent, to convince a court to take jurisdiction and refuse to recognize a foreign custody decree from Asia. So these general principles come to help American litigants too. It's a two-way street. And I don't think that the courts in the U.S. can take a foreign law and invalidate a local law. However, like I said, if the governing law in the choice of law in the contract is Saudi law or a specific law, that law governs. But even in that circumstance, you still can argue certain parts of the law should not be recognized because they are not forum nonconvenience arguments, constitutional violation arguments. For example, the uniform, it's called the UCCJEA, the Uniform Child Custody Enforcement Act, provides when there's a foreign custody decree, you, state judge, are only required to give it comity as long as it doesn't violate international human rights. And some of the state adoptions of this uniform law talk about that the law that rendered that custody decision is in substantial conformity to our state law. So in other words, we already have these protections, not only in some of the statutes, but based on common law and statutes that public policy and constitutional arguments are always there. So this whole hoopla is about nothing. It's targeting the Muslim community because people disagree with the Muslim community, have a misunderstanding of the Muslim community, and in the end, it hurts our country. Because as long as we have insidious, practical discrimination against the community, that means our civil society is not harmonious. It means it's going to fuel more misunderstanding, more violence, more problems. It's understanding. That's why my understanding of the Federalist Society is to have these debates so we can better understand each other. Because me and him don't see eye to eye. But the core principles of this country is what gives me the passion to be here before you and argue. Just like that's what brings him here to argue. Eventually, these arguments, I hope, will bring us closer to understand that Sharia is not the boogeyman, Muslims are not the enemy. If a person is a criminal, he's a criminal, but not his entire religious faith.
Well, let me say that the idea that people here think that Muslims are the enemy or the Muslim religion is somehow wrong, that is just untrue. And that brings an element into what should be a substantive debate on the law, into an area that is used to try to intimidate the other side. Sharia, in fact, is the crucial fault line in an internecine struggle that's going on internationally in the Islamic community. And it's a internecine struggle between fundamentalist jihadists and Muslim reformers and authentic moderates. People like the former president of Indonesia, who was a leader of the world's largest libertarian Muslim organization, I'm probably mispronouncing this, not a lot to Ulama, whose members espouse the enlightenment embrace of reason, and specifically the separation of spiritual and secular realms. For those moderates, Sharia is a reference point for personal conduct, not a body of law or a corpus to be imposed on the entire life of a pluralistic society. That's an entirely different view that fundamentalist jihadists have, who see Sharia as a way of imposing this global totalitarian system, cloaked as an Islamic state. And there's this huge struggle going on between these two. And the question that you asked earlier, that this law is practiced in different ways in different parts of the Middle East, and some of the things that we consider completely unacceptable. For example, the Human Rights Commission of Pakistan, recently issued a report. And the report was on honor killings, which apparently in Pakistan under Sharia law are perfectly acceptable under the law. And the Human Rights Commission there reported that almost 1,000 Pakistani women were killed by their families killings, in these honor killings, and none of the individuals, the men who did this, were prosecuted. Why? Because it's acceptable under their version of Sharia law. Now, yes, that is not acceptable in the United States. And yes, the Constitution is the ultimate law of the land. But we can already see, the advantage of a provision like this is to prevent what happened in the New Jersey case that we talked about earlier. And what happened in that New Jersey case? In that New Jersey case, because there's no such provision in New Jersey, the lower court judge accepted a Sharia law defense, accepted the testimony of this man's imam, and I understand the professor disagrees with the expert in that case's view of Sharia law and whether or not it justified what was happening. But the point is, the lower court judge accepted this. Now, fortunately, he was overturned by an appellate judge. But the advantage of a statute like this would be that at the trial court level, and as all of you know, appeals are expensive. You can't always appeal. Not every case is appeal. But the advantage of a law like this is that a lawyer in front of a trial judge, if the judge starts accepting or taking testimony on religious law, I don't care whether it's Sharia law, the Roman Catholic law, or any other kind of law, starts accepting that, for example, as a defense in a case, the lawyer has the ability on the other side to stand up and say, Your Honor, you can't do that. That is unacceptable under state law, and here's the provision that says you can't do that.
You don't need a provision, because that is the law, that the judge cannot accept any justification for the violation of these criminal statutes. Honor killing has no foundation whatsoever in Islamic law. It is illegal. It is illegal to kill anyone. In fact,
Not in Pakistan.
it is illegal.
It's
It
not
is
in
unacceptable. Story of the Prophet. In Islam, there is a capital punishment for unlawful sexual relations. You are remiss to be able to find a story of an execution in the past 800-900 years in the classical text. The reason why is to be able to demonstrate and prove an unlawful sexual relationship requires such a heightened burden of proof. 4 witnesses actually witnessing the sexual relationship and intercourse, the genitals, seeing them, and unanimity to go to testify that they had sexual relationship, that the law would apply. It is impossible to prove that burden. There is procedural due process in Islamic criminal law that is more excessive than the procedural due process we have in this country. Even an admission, a confession can be withdrawn at the moment before the execution, and the case has to start anew. Number 2, honor killings are illegal because there is no right to kill somebody without a court of law, a hearing. These are individuals that use their traditional tribal backgrounds that will do this prior to Islam. This is unacceptable. For Hans to say that it is acceptable in Pakistan, maybe there is an excessive problem in Pakistan, and that's an issue they have to deal with, but it has nothing to do with Islam or Islamic law. But one more point. This issue regarding genuine religious beliefs. Genuine religious beliefs can come into play in many circumstances, including our jurisprudence that talks about a reasonable accommodation in a workplace, or reasonable accommodations for inmates. So if we're going to start saying that any genuine religious belief has no role in the adjudication of cases, that's contrary to 100 years of our law. We go back to the same point. Bright line rules are not the solution. These general principles are already present in our law and have been functioning and working quite well and better than anywhere else in the world. So the request for bright line rule is discriminatory.
Mr. Desai and Mr. McGinnis.
Are any efforts made to codify the Sharia law? And from each country to country, there are variations, like you said, in the laws, interpretation and implementation. One one of the experiences in the same country, if you go to 2 or 3 different schools of thoughts like you mentioned, they have different interpretation. So in that kind of situation, what happens in this country for the application of that kind of law?
First thing is, abstract questions are very good theoretically, but we need to see actual examples to see how that would interplay. I'll give you some examples. If you look at family law, in most of the Muslim countries, it's codified. So you're actually looking at the codification of Islamic family law. So the rule is there. While to some that codification, for example, for me, the codification I think has been detrimental to the better, just adjudication of cases. Because the genius of Sharia and the way the Sharia functioned for 1,300 years was this humanitarian and more mediation-oriented adjudication of cases. So the judge had much more leeway to be able to balance the facts and things before him. But we do have these codifications. In the Delaware case, for example, because the case was in Saudi Arabia, everybody knows that Hanbali school of law governs that region. Therefore, the Hanbali jurists, their texts were the law for interpretation. If you go to Pakistan, in Pakistan, it's the Hanafi school. You would read their statutes and they would say if there is no clear express rule in the statute, you go to Hanafi law. So there you have the Hanafi law. The Ottoman Empire codified Islamic law in the 1800s called the Majalla. That also was a codification of Hanafi law. So yes, there are these multiple schools with different perspectives. For purpose of scholarly debate, those perspectives are enriching and diverse and dynamic. But when you're looking at nation-state laws around the Muslim world, most of these countries subscribe to one particular school. The codification, however, has been a mixed match. But because it's already a mixed match, it's already codified. So the interpretation is really not subject to various diverse interpretation. Your issue would be more from an academic perspective at looking at all these diversities. And when the case is so various and the interpretations are so various, neutral principles of law say if it's so uncertain that it's not governing. So again, I don't need a rule to tell me Sharia is not codified, it's in the eye of the beholder, should not be enforceable. Well, if the expert testimony before the judge demonstrates that it is not ascertainable and it's diverse based on that specific issue, well, neutral principles of law would not recognize it. So again, we go back to the same point, we don't need a bright line rule. The bright line rule only is targeting the Muslim community and has insidious intent.
So in
Final
other words,
question. We will let Mr. McGinnis give the last question.
in other words, go ahead. In other words, it is subject to the interpretation of the codified rules and regulations rather than following the statutes like what we have here in this country.
No, we have statutes here, and in many Muslim countries they have statutes too. In fact, Sharia is much more in sync with common law than with the civil law system. The civil law system is statutory. And the Middle East countries, now one very interesting example, because this is very important. I will not only testify about Sharia, I've testified a few times on, I've written reports on Jewish law, and I've written reports on canon law that involve litigation in this country. For many of you, especially Hans, who believes that the Sharia jihadis, which are a minutia of the 1.2 billion in this country and are insignificant for purposes of what's going on in the Middle East, they talk about Sharia overturning and supplementing all laws. Sharia is a pluralistic legal system. Sharia never applied to non-Muslims. For example, till today, you go to, I'm a Palestinian ancestry. I come from a small village in Palestine. Next village is Christian, my village is Muslim. In a divorce from my village, the law that would govern would be Sharia law because they are Muslim that are married. Divorce, custody, child support, inheritance would be Muslim law. The next village, Divorce, custody, inheritance, and marriage is governed by canon law. If they are Catholic, they have a codified Catholic family law code. If you're Orthodox, you have Orthodox family law code. If you are Anglican, they have the Protestant codified family law code. And the ecclesiastical court and the rabbinic court have the exclusive jurisdiction to resolve disputes amongst these communities. Never was Islamic law, specifically in this realm, applied to non-Muslims. There was autonomy. So therefore, even from a classical perspective, there was no hegemony of Sharia over non-Muslims. Imagine today in the 21st century, in the rise of the nation state and what we believe is citizenship beyond religion and ethnicity, how is Sharia going to be forcing non-Muslims to comply with their dictates when it doesn't apply to them?
Oh, I just wanted to make sure I understood the debate you guys are having about the New Jersey case. So you're saying that the statute in New Jersey says that in order to rape your wife, you have to do so intentionally, and the purpose of the imam coming in and speaking was to say that because of his religious beliefs, he didn't think he was doing something that he wasn't able to do. So it goes to his mental state, not towards the fact that because he thought it was okay, it's okay.
Yeah, well, the statute does not require a purposeful intent. The trial judge read the statute to require purposeful intent. And because of his reading, he looked at the genuine belief that he didn't think he was doing something unlawful. The statute, that element of the statute was not satisfied. But the appellate court said to the judge, there is no purposeful intent required. It just needed to be knowing.
So it was overturned because they mixed up the mental state, not
Exactly.
because the appellate court said you can't apply this law.
No. And of course, on the side, the court is saying, are you out of your mind? Even if there was, this is not justified. Do you see?
Yeah.
So it's more of a technical issue. And again, these technicalities, these legal subtleties about all of these cases around the country is absent in the discussion with Hans. He's just focused on this big paranoia that Sharia is horrible and we need a law to protect Americans.
So can I then extend that question to Hans to say what's your answer to that?
The judge allowed the husband's imam to testify that a wife must comply with her husband's sexual demands of the Sharia law, but the imam refused to answer whether under Islamic law a husband must stop his sexual advances if his wife says no. That's what happened in that case.
But it's
Now,
about-
I was hoping we would stick to the law, and U.S. law, and not talk about Sharia, good, bad, or indifferent. But everything I keep hearing from Professor Awad reminds me, my father was Russian. He escaped the communists, came to this country, and he used to tell me that he would always kind of laugh at people who would say to him that, oh, well, Marxism, communism, the way it's practiced in China and Russia, that's really not the way the theory is supposed to work. Well, anytime you want to look at anything, whether it's the law or political theory, you want to find out what that really is, then you look at how it is practiced. And if you want to look at countries in the Middle East where Sharia law is implemented and is the governing principle, what do you find? You find almost all of these countries, with some exceptions, they reject the bedrock principles of Western democracy. They reject the idea that the governed have the right to make law for themselves, the very idea of Republican democracy like us.
But I think you're answering a question that I didn't ask. What I'm saying is, his argument is that they're using that understanding to see how it fits into American law, not saying that that is what is now going to be American law.
Well,
So there's a difference in between what you're saying and what he's saying.
In American courts, they should be applying American laws.
But they are.
That are established in the common law and are passed by the legislature, and they should not be considering religious defenses, I don't care which religion it is, in a case like the one that occurred in New Jersey.
So what do you consider when you're trying to figure out what's in someone's head? Should you not consider anything? You're going to consider the things that are relative to their life to figure out what their mental state was. That's how you do it with any statute.
Well, in this particular case, it was being used to establish a defense to what I consider to have been criminal conduct. And I don't think that that should have been considered by the court at all. That if there had been a statute saying it can't be considered, it would not.
One final question, and we'll give each participant 30 seconds to respond.
Okay, you're saying that Pakistan may be an exception when it comes to honor killings and Sharia, but there's in Pakistan, a few hundred women were killed due to honor killings. In the world, over 5,000, so obviously they're not all in Pakistan. So the way Sharia is applied and the way it's in theory may be two different things. And also the second part about the legal will, yes, anybody can say, I wanted to have this will distributed according to Christian or Muslim or a different faith, but isn't there already a method to write down a will, and it's according to U.S. laws? And also, I'm sorry, the last question is really, what should we consider was one of the questions that was raised. What should we consider what should the judge consider? The intent of the legislature, the state, and the federal legislature. That's what they've been doing since the beginning. So I don't think that's a difficult question to answer.
First, the last question, he's thinking like a lawyer. So he's actually thinking because he wants to sit down, he's going to take a fact pattern on the bar, he's trying to dissect the facts and try to see where does all this fit. And he's seeing the legal subtleties, which is, it's a legal issue under New Jersey law about intent. That facts that were surrounding it were used to try to say that intent once is there. The judge's interpretation of those facts was erroneous. It's not religious law that's governing in the interpretation in New Jersey. It was state law. As it pertains to honor killings, I go again and again. Honor killings are illegal, have no basis under Islamic law. The person who commits it is damned to hellfire. There is no justification. You're talking about culture, tribal culture, with honor and shame that emanates and creates all of this honor killing. Not Sharia, not Islam. Islam, from its founding, was attempting to stop these types of things. Infanticide, creating a procedural due process that people are not the judge and juror, against tribal customs, against extrajudicial killings. These honor killings are unacceptable, period.
Hans, would you like a last word on that topic?
Well, I would just say, just look at how Sharia law is practiced in most parts of the Middle East, including the fact that women are treated basically almost as chattels, and I think that tells you the danger that it poses.
Okay, well, thank you very much to both of our participants. Briefly, we have a few questions. We have a few announcements. First of all, anyone graduating 3Ls and 4Ls, you can online now for free register for the Federal Society of Lawyers chapter. And anyone who will be returning as a full-time student or part-time student next semester, you can go online to fedsoc.org and join the national chapter for only $5. And finally, we will have our last event of the semester of the Craig Rossman Presidency next Tuesday, April 17th, right here in Baker Courtroom. Institute for Justice attorney Scott Bullock will be giving his presentation on post-kilo backlash to eminent domain. It'll be right here at 12:35 in Baker Courtroom. Thanks again to everyone for attending, and we hope to see you next Tuesday and next fall when President Dave Vitale takes over. Okay, thank you very much.